They still live streamed. They did that all during COVID, but I didn't realize they still did it.
Okay, we're ready. This is 24 CV 000278. Friends of Piney Grove et al. Versus the Bluffs at Lennox Homeowners Association. And we are here today, I believe, just to work through, I say just, it's a complicated situation, but the focus of today is to work through a motion for interlocutory injunction that the plaintiffs have filed concerning their access to a cemetery that they contend is a public cemetery, and the defendant's ongoing obligation to maintain that cemetery. There's been a complaint filed, but we're here to work through the motion for the interlocutory injunction. It would help me to know who will be speaking on behalf of the plaintiffs, and then we'll do the same for the defendants.
Yes, Your Honor. Mike McConnell with Jones Day.
And who do you have with you, Mr. McConnell?
Yes, to my right is Mr. Gus Todd and also Ms. Ashley Petrell-Hinkson. And then the plaintiffs are here, Your Honor. If I could introduce them to you.
Ms. Jackson and Ms. Collins.
Yes.
That would be great.
Right back here. And Audrey Collins to the left and Ms. Jackson.
Welcome to you both, and I'm sorry you had to wait on those benches. We should have had you sit on the softer seats during that delay, but I'd not been summoned like that before. Okay, welcome all of you, and on behalf of the Homeowners Association.
I'm Kate Whitlock from McGangus, Gowdlock, and Curry, which we just say MGC because nobody knows how to pronounce it. With me, I have Tom Whidden and Robert Butler.
Great, thank you.
Excuse me, Judge, we have one administrative matter when you get to it that we want to take up before argument. I've spoken to Mr. McConnell about this.
Okay, great. Well, we'll take up administrative. Why don't we take up the administrative matters? Because I'm going to give you my limited understanding of where we are, just so you know things you don't need to educate me on, or things you better re-educate me on if I'm misapprehending a situation. And then we'll dive into it. My administrative thing is that we were supposed to start at 1. We couldn't. I was booked by our probate judge to be the marriage guy from 3 to 4. So I'm going to another courtroom at 3 to provide free wedding ceremonies to anyone who wants to get married on Valentine's Day. So we'll get done what we can between now and 3. Some of me thinks we ought to get through this within that amount of time. I was pretty confident 2 hours would have been more than enough, hence the 1 p.m. start time. So once I'm done doing my hour of free marriage services, I can come back. So just to let people know, if we are running longer than 47 minutes, I'll come back. We don't need to finish. We'll pause and you can circulate. You can sit on the more comfortable seats if you're waiting for me. But I had those 2 bookends, which was lunch, which I didn't get, and the 3 o'clock, and those got shifted around. So I apologize, but I need to get that part out there. Ms. Whitlock, your administrative matter.
Yes, sir. Our answer was filed without a signature on it. We've done some research. We don't think that puts us in default, but so that you didn't have to make a decision, they didn't have to do research, we filed an amended answer, and we represented to the court that we would pay costs. But because of the hack into the Fulton County system, the clerk has not been able to process any money. So we've got the check. We're prepared to pay costs. We will pay it as soon as the clerk is able to take it. Okay.
We're told to call it the cyber incident.
Okay.
You can call it whatever you want. It was a hack, but our PR people have said that we have to call it a cyber incident. I have a 4-letter word for it because it's made life very difficult. But if the unsigned answer had been filed when you did, that was within the 30-day window, or this has all moved pretty quickly, but apparently not that quickly if you were actually running into a possible default.
So we did file on the 30th day. We filed the amendment on the 31st day. And I think it's the 20th that would be our 15th day. So because we don't know when cyber incidents will resolve, I don't know how much time it will take till they're ready.
Sure, but we're well within the 15-day window where you may, as a matter of right, open the default.
Yes, sir.
Okay, and this isn't how this case would sort out anyway. So I appreciate Mr. McConnell and his team saying, you can sort through this. They're not going to stand in the way of that. Great. Okay. Anything administrative from your side, Mr. McConnell?
We did have one agreement, and I know if this would be a good time to do it. It's just in terms of tendering the evidence.
Okay.
And just go ahead and knock that out at the beginning of the proceeding.
Okay.
So, and I will go ahead and do it for both sides because we've agreed to it. And so what I would recommend is that we will tender the verified complaint into evidence. They can tender the verified answer, and that's also we're tendering the appendix of materials filed in support of our motion for interlocutory injunction. I'm not sure there were exhibits with the response. We don't, I would tender those, but we look, but if there are any exhibits to the response, those are, should be tendered as well. We also, the exhibits that both sides provided last night to the court prior to the close of business also should be tendered at this time. And I would move for their admission subject to possible objections for discrete exhibits at some later time. I just want to make sure I'm capturing, Ms. Whitlock, what you had told me.
And I think that's correct, Judge. My question to you is, I didn't object to tendering everything. I do have objections to the admission of the evidence, certain evidence, and I don't know how you want to hear that. I can tell you all of them right now, and then you can make decisions later. I just don't know how you want to handle that, but I'll handle it however you'd like to.
Okay. Let me ask Ms. Niles a question first. In our Friends of Piney Grove folder, there is a subfolder that's defendants exhibits. Are there exhibits elsewhere, or is there a file that would be plaintiffs exhibits? Okay, got it. I appreciate collaboration on this front because it's administrivia, which isn't to suggest you have trivial objections, but the more we can collaborate to say, look, here's the evidence, and am I going to make you lay a foundation for this photo? That's a photograph of a gravestone in the cemetery. I guess what would be helpful, Ms. Whitlock, would be if you let me know which exhibits to which you have objections. I would love an exhibit list if both sides have that. And it may be that it is in this folder here somewhere. I just want to give Ms. Niles a chance to look for that. So for defendants exhibits, I wonder if I'm in the wrong folder. There's a photograph of like a door and then something called defendants exhibit 1.
No, that's, and what I got from plaintiffs was the affidavits.
Okay, just affidavits? Okay.
And there was a video link, but we assume not.
Okay, got it. Ms. Collins, Ms. Marcus had affidavits. Okay, well, if you've got a exhibit list, that will put it in a little context when Ms. Whitlock says, I don't like exhibit 92. I don't know what that is.
In your honor, we don't have a comprehensive list of all these materials. Our appendix of materials, I do believe, had listed, and it's in the table of contents.
How about this? Do I have my own binder? Yes? Great. If you just give me a binder, then I can work with that.
What the index so that I can look at it.
Courtesy copy to the court. We provided a courtesy copy. That's what I was referring to, your honor. This is mine.
Oh, I don't want to take your binder. What's the name of the document I should be looking at that would give me a list of your exhibits?
It would be the notice of filing.
That was filed with our motion for interlocutory injunction.
Filed with the motion for interlocutory injunction, which I believe is January 10th.
Here we go.
And there should be an index in the front. There's page 8 of the PDF. And it should be listed there.
The notice of filing I've got is handwritten, says attached are exhibits A and B.
This is a separate one that was filed in connection with the verified complaint, your honor.
Oh, NOF. Got it. Page 8 there. Oh, look at that. Holy smokes. Okay.
And then if you turn, there's about behind exhibit A is a plaintiff's appendix of documentary materials reference plaintiff's verified complaint. And then behind that is this index of each of the materials.
Is this different from, I have a list of 50 exhibits.
Correct.
Same thing?
Same thing.
Okay, got it. Which numbers give you heartburn, Ms. Whitlock?
So it's easier, Judge, to go at it the other way and tell you which ones I don't object to. And then I can give you a global objection to the rest of them.
Okay, hold on. For future reference, it's really helpful to have an exhibit list that you can hand to judge, staff attorney, all that kind of stuff.
Yes, Your Honor.
All right, I'm gonna print it out so I can mark it up. But that sounds ominous, that it's easier to say the things you don't object to. We may need to be here all night. Okay, 1 through 50. Tell me what you want to tell me about it.
So numbers 5 and 6 are letters between the lawyers. Erin O'Connell is the general counsel for the Homeowners Association.
Okay,
And I believe the letter was from,
you know what? This is gonna take too long if you give me too much info. So
Okay,
5 and
so
6, you have
5
no
and 6, I do
objection.
not object to. 19 through and 20, I do not object to. And 28 through 35, I do not object to. 37, I do not object to.
Hold on.
Oh, sorry.
All right,
And
35,
excuse me, 28 through 35.
right?
37 and 43.
Okay,
The rest of them, Judge, are press releases, newspaper articles. I think they got some from local papers, but they are all hearsay. Most of them are hearsay within hearsay. They did submit the affidavit of a lawyer who said, yes, I went and found these, and I'm giving you true and accurate copies of what I found. But that is not a foundation that tells us that the custodian of records agrees that they are true and accurate copies. We don't have the reporters. We don't have the people who talked to those reporters. So we think that that is all inadmissible hearsay, does not come within any exception to the hearsay rule. And we would object to the court considering that on the interlocutory injunction. It's just like any other motion or opportunity for evidence. They have to submit admissible evidence.
what about 45 through 50?
Our problem with those, Judge, is that they are surveys that are all different. And they have a little bit different lines. They have a little bit different, you can see that they're years old. So I can't, and that is one of the significant points, is where is this cemetery? So we would need to examine the people who did the surveys, why they come up, why are they different, before we think those would be admissible.
Okay,
And on the 3 affidavits, Your Honor, we object to those for the same reasons. Ms. Palmeter, I don't doubt that what she's saying is true, but it's not enough to lay a foundation for the documents. And both the affidavits that they submitted last night were not based on personal knowledge. For example, this is just one paragraph in the affidavit of Ms. Beth Marcus, but paragraph 17, she says, after a consultation with Ms. Kibbe, somebody else, who I think she's talking about, Ms. Beasley, informed the friends that several small trees were obstructing the goat's access. that is not personal knowledge. She is reporting what somebody else told to her.
Okay, you're getting way ahead, but I appreciate your concern, and it seems like those concerns might be a reason to exclude that kind of information, but I appreciate all that. Let me talk a little bit about what I understand the dispute to be, and then we're going to dive into this. There is a cemetery. There's no debate about that. Its exact contours may be at issue, but its general location is not in dispute. And as I understand it, there's in fact a city ordinance that says you can build in this area, but access has to be provided to the cemetery, and the cemetery will be maintained, whatever maintained may mean, and I think there's some space for litigation, maintained by the homeowners association, which I assume, whether it's always been, I'm going to call it Bluffs for short, whether it's always been Bluffs or just through assignment and whatnot, it is now Bluffs. It is Bluffs that has that ordinance obligation to maintain the cemetery. There is also a declaration, part of the declaration of the homeowners association obligates the HOA to maintain the cemetery. The plaintiffs are alleging that that maintenance has not occurred, or what maintenance did occur was insufficient. I don't know if it's the plaintiffs per se, but some people have engaged in self-help. There's the goat incident. Maybe some trees have been cut down that are on Bluff's property that people felt they ought to be able to cut down because through self-help they were maintaining the cemetery. But there doesn't seem to be much legal dispute, as in what did the ordinance say, what does the declaration say about an absolute right of access that people enjoy to the cemetery and an obligation of the defendant to maintain the cemetery. Where I think we ought to explore today is, what does maintenance mean? And really what I want you to start with, Mr. McConnell, beyond any opening you wanted to give, is what's the irreparable harm that justifies action now, short of there's a complete denial of access? In other words, if you're going to show me these people can't even get in, because they're forbidden access, there's a gate, or trees have fallen over the only way to get in, then I'm starting to get the sense of irreparable harm. But if it's not as clean as it should be, it's in disrepair, that doesn't strike me as an irreparable harm situation so much as I understand why we're litigating, and the homeowners association may be at risk of incurring additional damages or liable for additional damages the longer it is in disrepair. But you're asking for me to order someone to do something, and that's an extraordinary remedy, and that requires some showing of irreparable harm. And as I read through the pleadings, that didn't jump out at me, that if I did nothing today other than to say thank you for being here and moved on, what's the irreparable harm? So take it from there, Mr. McConnell.
Thank you, Your Honor. I can approach the podium.
Please.
If I could correct, I think one reason for where the court is starting, if we were here saying what they had to do to maintain, and that was what we were seeking injunctive relief for, that would be a mandatory injunction.
So let me stop you. Any order that would say, let's change the status quo and allow people to do things that maybe they haven't been able to do, how is that consistent with what an injunction is supposed to do? Changing the status quo. Let more goats come in. Didn't go so well the first time.
And that's a factual issue, Your Honor, but let's just assume that's the case. The status quo here has been disrupted not by the request we're making here. That property right existed, and they've already said and agreed that they are heirs, that Ms. Collins and Ms. Jackson are heirs. And as a result, they have an easement interest in that property. And that easement interest under Georgia law is not limited to any specific burial plot. At this time, what they have said in their restriction in the letters is that you can only tend to a specific burial plot. You can't try to clear vegetation that may be obstructing access to that burial plot. You cannot take any other steps But under Georgia law, both for a public cemetery, which we would have to discuss with you, but this, there's no dispute, they have this easement interest right now. And under Georgia law, a cemetery includes not only lots for depositing bodies of the dead, but also avenues, walks, and grounds, right? And so that's the scope of it. And lot owners, and this is Arlington Cemetery versus Bending,
You have
212,
sorry, you were about to give me the site.
212 Georgia, 698, 1956. Lot owners, and in that instance, it's the same treatment as someone who has an interest in that plot where someone's buried.
You're making a leap there. So when you say lot owners, you're saying someone with an easement interest is a lot
Correct.
owner?
Yes.
And how does that work?
Because in the Arlington case, it was a public cemetery case. And these lots had not all been assigned yet. And they were saying, well, how far were your interests beyond where you may have had an interest in a particular lot, or you may have had a descendant in a particular lot. So the basis for that is once there's somebody buried, that creates that easement interest. And irrespective of whether it's through a lot ownership, whether it's through some other by operation of law. But the point that is the key point here in that decision, and I'm quoting from page 704, lot owners have an interest in the preservation of the cemetery in its entirety. And it is not necessary that all of the lands of the cemetery corporation be laid out in lots for lot owners to have an interest in the preservation of the entire lands for cemetery purposes. And the reason that's important, Your Honor, for purposes of this hearing, is you cannot physically access the graves in the cemetery. There is an access alley behind the townhomes, but once you get to the cemetery, you cannot traverse it.
When you say you can't, you and I aren't there, as in there's barbed wire and you would die, or it's difficult because there's thick vegetation, or there's a wall, or what does can't mean?
There's thick vegetation. There are fallen trees, significantly large fallen trees that are just strewn through the cemetery. There are gravestones that had been toppled over from harm being done to it. Remember, this cemetery isn't just a particular grave site. It's the ability to walk through the grave site.
I remember you told me like 2 minutes ago, so
Okay.
I remember.
So the point is, though, you can't do that. They can't, and we are not asking here at this point for an order mandating that be done. All we're saying is that under Georgia law, we have an easement interest for the care and maintenance of the cemetery. And that care and maintenance duty extends beyond the few things that they have authorized. Because an example, what if you can't even find the grave? What if the grave site doesn't have a headstone? What if the grave site, which many of these out there only had markers, because that's all that could be afforded to put out there, and it's obscured. So you are effectively, not you, Your Honor, but they are effectively, by allowing all of this overgrowth to continue, to obliterate any ability. And under Georgia law, any impairment of a property interest is deemed irreparable. And that's Focus Entertainment decision that was entered by Judge Eldridge on the Court of Appeals, and said quite clearly there that if you have an easement, a property interest is unique, and that if there's some interference with that is grounds for irreparable harm. It's not incapable of monetary damages. How do you compensate monetarily if you are a descendant, such as we have pointed out in the verified complaint, and you would like to put a headstone where your grandfather's located or your father's located, and you can't even physically get there because of all the obstructions, and you can't physically find it because of all the obstructions. So by that inactivity, you're obliterating any ability to care and maintain for the burial site.
So your relief requested is not an order directing the homeowners association to go in there and clean it up. It's authorizing.
Right.
Who-
It
who
is
to do
authorized.
what?
Oh, it is
How do I frame that?
authorizing plaintiffs to do what we have set forth in pages 4 and 5 of our motion, Your Honor. And those items, which, they are lengthy, but the reason.
This is the A through N.
Yes,
and
Your
Nancy.
Honor. The reason they're lengthy is I wanted to add specificity for the court. I didn't want to make this a vague order and make it difficult. I wanted to try to be as precise as I could. Now, what I used, this wasn't something that I came up with. A lot of these are straight out of the Georgia statute. I'm not saying it applies to them, but it is a statute in Georgia on what you have for the maintenance and care. And I believe that's, if we can go to that slide. And this is just a slide that is directed at funeral home, licensed funeral home. So I'm not implying that that's what, but I use this as a basis to try to come up with what would make sense.
Sure.
If it makes sense for them, I would think it would make sense here. So G, mowing grass, H, raking and cleaning, I, pruning of shrubs,
Don't
J,
see
suppressing.
Goats in there, but.
You
yeah,
don't, Your Honor, and I was going to come back to that.
Okay.
But then I was just going to tick these off if I could. And then N is the last one, which is include repair or restoration of improvements necessary or desirable as a result of wear, deterioration, accident, damage, or destruction. And it doesn't specify how you do that. So there is certainly reasonableness as to how to go about doing that. And I know that, we'll get into the goats, Your Honor, and we're happy to talk about that.
If you were standing in the middle of what you understand to be the four, I'm going to pretend it's a square, the four corners of the cemetery, and you took out a chainsaw and started cutting up a dead tree that was in the middle, are units of the HOA close enough that if you were doing that at 4 a.m, everyone's going to hear that? Or are we talking about a sacred and important piece of land that is so far away from the HOA that it really doesn't matter the methods that are used because they wouldn't be a nuisance or interfering with the HOA occupants' right to quiet enjoyment of their property?
It's adjacent to their property. So I would think, Your Honor, if you had a chainsaw, they would hear it.
Okay.
That would be.
I mean, we're talking about that degree of proximity.
That's exactly right.
Okay.
They are literally abutting the cemetery, but of course, that's the reason everyone was so concerned in 2006 is what was going to happen
Sure.
to this cemetery.
Why there's an ordinance saying that this needs to happen.
And to the point, I mean, if a chainsaw is necessary and we were doing it, it would only be because they haven't done it, right? And if they were in our position, I know they dispute it, but if they were doing it, the same homeowners would have to hear it, whether they were doing it or whether
Sure.
they were doing it. And I would agree that we wouldn't do it at 4 a.m. Right?
I didn't think you would.
But I think all of these are subject to a rule of reasonableness. And with respect to the goats, let me just go ahead and clarify that. I know they submitted a video last night. The goats did get out. We'd already said that in our verified complaint.
I actually knew it because you put it in your complaint. So
we acknowledge that. We submitted a video as well, which shows the goats inside. Well, I mean, the cemetery when they were doing their work there. For the most part, the goats, it's my understanding, and I think this is based upon the affidavits we submitted last night, they were roughly out there for about a month. And really, there were very few, if complaints. And the one time that we did get one in June, it was handled very friendly manner. The service that is responsible for the goats is a reputable service, and they came out there and handled it, which incidentally, under Georgia law, you are entitled to hire someone to exercise your care and maintenance efforts. And that's been Georgia law for about 100 years. And I can cite the case, but I just wanted to mention that that's what we would try to do. And these other points, I think, are pretty common sense, Your Honor. You know, we're removing debris and plant obstructing access to graves.
I don't see an issue with A through N. As I've wrestled with this, it's more who is doing it and what are the guidelines in place. If it's not the HOA that's doing it, and it seems like they have an obligation to do it, then how do we ensure that if it is what I was referring to as the self-help, I don't, but if I were someone with an easement interest in it, I can't, like I gave my example, 4 a.m., show up with a lawnmower and say, I'm going to start clearing this path because I have a day job. So if I'm going to do this, I have to do it at night. And I have this access here. And so it's just sort of mediating
Sure.
Who would be taking care of it and how it would be done in the least intrusive manner at all. But you make a good point. If there's a tree that needs to be removed, there's going to be a chainsaw, and goats don't eat trees. So there's going to be a chainsaw in there, whether it has a HOA sticker on it or it's got a Friends of Piney Grove sticker on it. There's a chainsaw that's going. And for someone who works from home in the middle of the day, that's going to be an inconvenience, regardless of who's operating it.
Yes, Your Honor. And I agree. I mean, anytime you have the execution of this type of an injunction, it's going to require some level of cooperation and reasonableness, which, by the way, there was cooperation and reasonableness. They were out there in 2020. It really was working well and with the homeowners association. And they came out again this year in 2023. And the efforts, these were well-known efforts. They were publicized, and because it is of interest. I mean, this topic is of a lot of interest right now.
As some of your articles I'm familiar with, independent of this case, we have disappearing sites of historical significance and of familial importance to people, and it's important to allow development to occur, but it needs to be done in a thoughtful way that protects pre-existing important spaces.
Yes, Your Honor. And anyway, what we could do, I think, and given that they were working together, and that was the status quo. The status quo was, okay, come out and do this since you're heirs.
What changed?
We don't know.
Okay.
I think it was the tree incident. And that's the reason, but Ms. Marcus, we wanted to submit that so Your Honor would have our understanding of the facts. It was on a Saturday. I don't know, maybe they had not been there on weekends. I believe it was the treasurer who called, and it was a tree cut down. And the reason the trees were cut down, it wasn't just hacking trees down. It was because the goats couldn't access portions to go, and not even the goats could navigate them to get to where they needed to go.
That is telling.
And so, and that's what they were doing. Now, Your Honor, I know that they say that violated an ordinance and they sent a picture. I'm not so sure it did. It's supposed to be chest height. But putting that to the side, what we did, we didn't want to fight about it. And we sent them home that day and apologized. And then after that, we were informed, you're done. No more goats, don't come out. The only thing you can do is prune around, and I'm limiting it, but not a lot by a lot, around a particular grave. As
in your own, or you could prune around any gravesite?
The way I read it was only the ones you have an interest in.
Okay.
And so that's why we brought this case. And, and given that they were restricting those rights, of course, we're going to go into the others, which is, yes, I do think they have an obligation, but that's not before the court today. That's in a separate count, and we specifically didn't seek an injunctive relief on that.
Okay, so what you've helped me understand is that the immediate injunctive relief you're seeking would be, of course, to renew access to every point because per Arlington, your easement interest isn't into just the plot with which you can connect yourself through lineage or whatnot. But it's basically it's everywhere. It's the avenues, it's the access points, and et cetera. And to empower the plaintiffs to resume their maintenance work that they've done, because that easement interest, not only is it not limited geographically, i.e. to the plot with which I have an ancestry association, but it's not just an easement interest of access, but it can carry with it, I think you use the word duty. I don't usually think of easements as having duties, but at least it gives you the ability or the authority to engage in whatever would be reasonable care and maintenance of, again, not just the plot, but of all appurtenances of the cemetery as well. So it would be returning to the status quo that maybe existed up to what you called the tree incident.
Yes, Your Honor, which I believe was June of 2023 is when that occurred. And yes, Your Honor, that is exactly the relief we're seeking here today.
Okay.
And if I said duty, I misspoke.
Okay, that's what I wrote, but either way.
And what I meant is essentially the right. That's in the bundle of the easement rights.
Okay.
To care and maintain.
And then you are contending with my original question of what's the irreparable harm. The Focus Entertainment case, which you'll get me a cite for in a minute, stands for the proposition that, and now these are more my words, any abridgment of someone's property right constitutes or can constitute irreparable harm, because how do you monetize that? If I can't get to my backyard for whatever reason, because of something you're doing, that's irreparable harm. I'm not bleeding because of that. And actually I can go out my front door and go about my business, but that's my backyard. Or in this instance, this is my cemetery. It's a public cemetery, but I have an easement right to it because that was my great, great, great aunt, or however many greats it would be. I have a right to be there. My inability to be there in the full manner in which I'm entitled is per Focus Entertainment, irreparable harm.
That is correct, Your Honor. And Focus Entertainment, the site there is 253 Georgia Appeal 121 to 2001 decision. This is not a direct quote. This is my notes from the case, Your Honor, so I don't want to imply that. But I have written, land is sufficiently unique to be entitled to equitable remedies. I also believe we discussed this on pages maybe 10 of our memo. And in that case, the court cited a variety of cases in support of it being unique. One is the Rife, R-I-F-E decision, which was an easement case. And so, and we also mentioned other easement cases in our brief that stand for the same proposition, that in an injunction, even though you haven't established the easement per se, so, which in this case is the public part. The other, I would say, has been established, but the public part is not. But even though you haven't, if you have a substantial likelihood of success on that, then it's okay to then maintain the status quo that way. Do you,
I'm going to ask Ms. Whitlock in a moment, her thoughts about, is this a public cemetery or not? Do you have any concerns? Your brief rattled off the 9 different ways. It is very thorough. I'm wondering if there was a particular part you were worried about that you want to address now in terms of some claim that this is somehow not a public cemetery.
No, Your Honor. Well, I was really ready to go into them in detail, but it's obvious you have gone through it in a lot of detail. And because I think almost most of those are abundantly shown by the evidence. It's been in use for over 100 years, which is 50 years longer than the Hasslerig case, which is the seminal decision in this area. We have both acquiescence and, I believe, based upon testimony in the verified complaint or oral histories of people that recall, there was actual express permission by the church during that time to bury folks there. So I was prepared to go through the 9, but I didn't feel that any were needed embellishment.
Okay. No, I agree. And I think even if it's gray at the edges, but I will give Ms. Whitlock a chance to address it. The ordinance kind of fixes all that. Kind of, I don't know how you get around that one if you're trying to say this is super private space to which no one has access, when the city has said, no, it's not, but we'll see.
Okay.
Okay.
Yes, Your Honor. That was, as far as the public cemetery point, that was it. And no other questions. I unless the court wanted me to discuss the other factors, because there's the 4 factors, but
For the injunctive relief.
for the injunctive.
No. I think that you pledge your case well. You pledge your case well in all areas. It's just the part that I had pushback on was the irreparable harm. I'm not a property lawyer, so I hadn't cast it in those terms. My doubt wasn't in any way that your clients were being harmed by the lack of maintenance and the inability to get to all the places they might want to go and are entitled to go. That wasn't the point at all. It was more so, wouldn't the fix be, if it's not right away, as this litigation goes forward, assuming your claims are meritorious, which I'm doing for the purposes of this analysis, to say to the homeowners association, go clean it up. You need to do that. You're required to do that under the ordinance, under your own declaration. Do your job. And then if they did, the harm is alleviated. This is just, I'm explaining my thinking as to why I didn't see it as irreparable. And if they didn't, well, they're a whole other set of issues, and there'll be a different type of harm to the homeowners association in terms of fines, fees, whatever it would be. But you're helping me understand that while that is a way in which this could play out, the deprivation of the property interest at the beginning can constitute, per Focus Entertainment, that irreparable harm.
And I just had one other point, Your Honor, and because I don't want to belabor anything. It was just something that I remembered that my clients did tell me, is that we are in a unique window right now for purposes of the care and maintenance, because we're just about to go into a new vegetation cycle. And now is the best time to try to get out there. It's going to make the job easier the sooner they can try to get out there.
Nope, that makes sense. As I run through my neighborhood with my dog, I can see everything because all the vegetation, the leaves are gone. I mean, you can navigate in ways that you can't in 3 months. And it sounds like if goats had trouble getting in parts of that place, it is indeed, unless you've got a helicopter airdropping you in, it's hard to get to certain spaces there.
Yes, Your Honor.
Okay.
Well, and that does it. Thank you, Your Honor.
All right, and I'll certainly come back to you as the movant, but I do want to give Ms. Whitlock a chance to say some things, and it does look like we're going to bump up against the 3 o'clock. I was hopeful maybe with the whole concept of marriage, you guys would settle this during the hour that I've committed to providing the free weddings. But Ms. Whitlock, why don't you get started at least with your take on this, and you're free to address any and all the things we were talking about. I want you to clear this hurdle for me first. Is your client contending that we're not dealing with a public cemetery, or is that not an issue of dispute?
That's a hard question to answer, Judge, because public cemetery has a specific meaning under Georgia law. We do not dispute that it is not our private cemetery, but we do not agree that it is open to everybody in the public.
Okay, so accepting that view for a minute, how would that change the analysis that Mr. McConnell and I just engaged in? That it is we'll call it a semi-private cemetery, to which I think you have conceded, and I'm not putting those words in your mouth, but that both Ms. Jackson and Ms. Collins do have access. They would be part of that semi-private club.
They would be part of the semi-private club, Judge, but we've got some issues when Mr. McConnell says it is undenied or undeniable that they have an easement interest. That is not correct. We think we haven't gotten to the evidence yet. We haven't done the discovery. The easement may have been abandoned, depending on what the facts are. And the ordinance that you're talking about, there may be foreclosure issues and other incidents which have occurred since the time that was passed that have affected the application of that.
So I've previewed before, I'm not a property lawyer, so this is not my wheelhouse, but I just so happen to be heading into a trial in a few weeks on easements. And I have learned through my preparation for that easements are really, really hard to abandon. tell me why you think that Ms. Collins or Ms. Jackson or any folks in their status where they can connect themselves to someone who was buried there, could have, would have, abandoned the easement.
Well, we start, Judge, with the definition of an abandoned cemetery, which is Code Section 3672(2). And it says an abandoned cemetery means a cemetery which shows signs of neglect, including without limitation, the unchecked growth of vegetation, repeated and unchecked acts of vandalism, or the disintegration of grave markers or boundaries, and for which no person can be found who is legally responsible and financially capable of upkeep of such cemetery. That is 3672(2) subsection 1. And then when you go to the case law, it talks about, and Thomas is going to find it for me in just a minute, but there is a case that says you have an easement to a gravesite until and unless it has been abandoned. And in this case, again, we haven't got to the evidence, but some of the articles that the plaintiffs submitted to the court indicate that the plaintiffs themselves had been to the cemetery when they were children and had not been back in years. And when they got back, it was overgrown and it was difficult to find grave markers and boundaries. So we think that that's a factual issue that we're just going to have to figure out if those rights have been abandoned such that they have essentially lost those rights. So we don't agree that they have the easement rights, but despite that, Judge, they have never been not allowed to go into the cemetery. Will you pull up our email number 1? So Judge, our exhibit number 1, which is in front of you, is an email that came out from Jane Beasley, who is the property manager. And you can see it went to Audrey Collins, Rhonda Jackson, and Beth Marcus. This is after the incident that Mr. McConnell referred to as the tree incident. And that did start to change the relationship. He is right about that. But if you look at that email, what we said, we explained, here's what the problem was, here's what happened. And then we concluded with, to maintain a harmonious relationship and prevent any further misunderstandings and as owners of the land, it is imperative that your nonprofit organizations seek our association's approval for any changes or alterations on our land going forward. This includes, but is not limited to, any modification or removal of vegetation, introduction of new animals, or any other significant activities that may affect the property. So, Your Honor, we submit that when you talk about a rule of reasonableness, we never said you can't come in. We just said if you're going to do something other than these minor things that Mr. McConnell was talking about, talk to us about it. Let's see, is 8 o'clock on the Saturday of Memorial Day the right time to do chainsaws? Probably not. So they've never been denied this access. And the concern that we have about the court ordering that the plaintiff be allowed to do this is they do it on our land, our liability. And there may be some question about that, Judge, but at this point, we're the ones that have liability. So if anything happens there, somebody can come back to us. And if you're looking at that definition of maintain, our position is that maintain means that we have to keep it in the same state as it was when it was given to us. And there's a factual question about what that was. But that means if they go forward and they add the paths and the improvements and the benches and all of that, that adds to the responsibility that we have. If we're supposed to maintain that, we've got to keep it the way it is. That will increase substantially the burden that the homeowners association has, because there's no question, Judge, about the maintain. That's in our covenant. So we do agree we have to do that.
Got it. But it's maintain what and at what level? And should the plaintiffs choose to invest time and money into making it look amazing, does that then become your client's obligation to maintain when it didn't look like that at any point since they've been responsible for it through the declaration?
Exactly.
Sort of an unfunded mandate.
Correct.
Okay.
Correct. So Judge, I know that you've got to leave, so I want to be very conscious of your time.
I need to step away. I will come back. It's
Okay.
not I'm hopping on the helicopter and leaving.
But if there's a question that you had, I'd like to address that. But really, you hit the most important part. We went through each of the 4 criteria, I don't think they meet any of them, but that first one is the most important, that irreparable harm. And I think when he talks about a property interest, the way I read that is that means because it is unique, he is entitled to equitable relief. It doesn't mean he's entitled to emergency equitable relief. So at the end of the case, you may decide, yes, I'm going to make you do this, or they can do that, but that doesn't change that this is not an urgent situation. The parties had been working together. There's no reason they can't continue to work together to try to maintain this at whatever level they agree until this case can come to you at the end of the usual course of discovery.
Well, that's what I think I struggled with the most as an unknowing coming to this from the outside, just reading the pleadings was the urgency, not in the sense of importance, not at that at all. This is a cemetery. And so it starts out as a fundamentally solemn, important space. It was the why now as opposed to let's flesh it all out. But some of the things that Mr. McConnell has said help me better understand a sense of urgency on the plaintiff's side. If there is a grave marker that is on the verge of complete decay and we wait 9 months to get through the litigation and this is all hypothetical, a tree falls and splinters it and destroys that grave marker, it's gone. I can't think of something more irreparable than that. The only way in which a plaintiff might have identified that this was John Smith's space is then gone. Not through anyone's fault. It's not a blame thing, but that would be a reason to act quickly. But you have flagged a few things I hadn't thought about, like the plaintiffs come in and they partially cut a tree down and you know what, let's not cut that one down. They leave, tree falls over, crushes a baby. Is that the homeowners association's liability? Your tree, your property, and it killed a kid. There are ways to navigate that, but it's not as simple as a stroke of a pen saying, let them within reason, within certain hours, do what they want to do. There are unanswered questions that lawyers think of. I am one only on TV. I hadn't thought about that it couldn't be carte blanche. And Mr. McConnell wasn't asking for carte blanche, but there are pieces of this that people need to be thoughtful about. I do have a question about the 4 factors. Tell me, in your words, I've got your answer and your response, but why is it? And one of them may be the easement's been abandoned and it's a semi-private cemetery. But your top 2 or 3 reasons why you think there's not a likelihood of success on the merits for the plaintiffs.
The main reason, Judge, is if the information that is before the court now, which I told you to start with, I'm not agreeing is evidence.
Understood.
But if the information before you is accurate and is in fact what happened, it started with a developer in 2006 saying, I want to move the cemetery.
Right.
And there was pushback from that, from some source. We don't know what, but there was some pushback. And so what he got was an ordinance from the city that said, okay, you can build there as long as you maintain the cemetery. So to me, that means you just can't destroy it. You can't move it. And he's saying, yeah, I got that. I got the pushback. I'm not going to do that.
It's maintain and provide access, which
Correct.
There's another area that needs to be litigated. If Ms. Collins can walk in the front gate of the cemetery and then as far as the eye can see, it's impenetrable kudzu. Is that access? Don't know. We don't have to solve that right now, but just it's 2 prongs. It's maintain, which could be don't touch it, your argument, but it's also the access piece. Okay, keep going.
And so yeah, I think you're right, Judge, but how do we get there? Who pays for it? You know, all those things are questions that can be answered over time. And we've just got too many unanswered questions at this point. You've also got, as I said, there's some questions about whether that ordinance is still in effect, given the title to the land and how it changed. And
why would, tell me, I don't want you to dive too deep. I'm not an ordinance expert either, but why would an ordinance is it that the ordinance applied to a land deal or the ordinance governs or applies to real property, which doesn't change? Thou shalt not develop this cemetery. That it really is, thou shalt maintain the cemetery and allow access. You're saying that might expire when Mr. Ahmed wasn't part of the deal anymore and it became Capital Partners, or maybe it was Capital Partners and then it went to JBGL. Why wouldn't it travel with the land?
Because foreclosures destroy all those rights, just like if it was a homeowners association, you've got covenants that run with the land, but if there is a foreclosure, then the covenant is severed.
Was there a foreclosure?
There was.
And that was it the Capital Partners who got foreclosed, or?
It was either Capital Partners or one after them.
But it was post ordinance,
Yes, sir.
but pre your declarations.
Correct.
Okay. So ordinance may be less sturdy than I'm saying it should be, but you still got your declarations to contend with.
Correct.
Okay.
Correct. And, you know, again, I think the covenants, and I'm pretty sure the covenant says that we will maintain. It doesn't say that we have to provide access, but we have continually, as we showed you in our brief, provided access. So we just think that there are too many questions at this point in time for there to be a decision that they are likely to succeed on the merits. And there's no question, I know we said this before, but I do want it to be very clear that nobody disagrees with the court that it is a solemn ground. We have been careful to maintain it, which is one of our concerns about the goats. They're not very careful about where they step, and some of those tombstones may be very fragile. And so we do have actual concerns about that. And if you watch the video we submitted, they got out, they're eating other people's. So there's just concerns. What our request would be is, instead of the court order that they can do this, if the court feels compelled to order something, that we'll work together and figure this out. And now that especially we've got lawyers involved, I'd like to think that we are reasonable and can come to some sort of solution to protect the property during the course of the litigation.
Right. I want to make sure the record is fully complete. I think you dropped a word off. You were referring to what the goats did, and you said, and they got out and they ate some people. You're not contending. I assume it was like people's shrubs or their greenery.
Yes,
okay.
I don't know of any goats that ate any people. It was shrubbery.
Okay, got it. That's what I thought you meant, but I want to make sure that word got in there. Okay.
Appreciate that, Judge.
I do need to go, but so I can be thinking about it while I am in this other courtroom. Mr. McConnell, your thoughts about ordinance being extinguished because of a foreclosure? That seems like there'd be some case that would have addressed that before. I'm not asking you to pull the case out of thin air. There's also a legal, I appreciate that foreclosure would extinguish covenants. I've not dealt with an ordinance connected to land.
And we will, and you're on it. I don't think it was in the brief, so I hadn't looked at it before coming into court, but we will do that in your absence.
Okay. Do you all have the ability to stick around till 4? Or I hate to do that to you, but I had committed to Judge Johnson, our probate judge, to do any walk-in marriage ceremonies today. It's why I wore the hearts on the tie, because I figured we'd start at 1. But I mean, this isn't helpful to your clients that you have to sit here for another hour, these large legal teams.
Yes, Your Honor. I understand, but
can you work on other things and bill other people while you're here so it's not hurting your clients?
Yes, and we would be happy to be here at 4 o'clock. Your Honor.
All right. You can be at ease. I will come back. It is 1 floor up and in the adjacent building, so I won't be far. But I need to live up to that commitment, and then we'll come back and talk a little bit more. One thing you can be talking about as lawyers is if there were an order that were to allow for there to be some fundamental maintenance in the form of clearing overgrowth, et cetera, the kinds of guardrails that everyone want to see in terms of, because the other thing I wanted you to address, Mr. McConnell, was this liability concern. That is just the super bright red light that went off once Ms. Whitlock said that. But I saw you nodding your head, so there's a solution out there. But be thinking about the type of language that would protect the homeowners association if it wasn't the homeowners association that was doing some of this fundamental ground vegetation clearance that balances everyone's interests. It's not going to be on Sundays or whatever people could agree to, knowing that in the end I'll be refereeing this, but it's good that lawyers are involved because you can't call, thank you, cyber attack, but cyber incident. But you can email Ms. Niles and we could all communicate in some way about it. But we could have some basic guidelines in there so that ideally 95% of what folks want to do, they could get done and it wouldn't bump up against, McConnell needs to talk to Whitlock because they've decided they need a Bobcat. The only way to move this is to get a Bobcat in there. And that's not what was contemplated. What was contemplated was you get landscapers in there using mowers and blowers and whatnot. So the more you could talk about agreed upon dispute resolution, limitations, et cetera, because I'm going to turn to you anyway on that, but you could be using this time that we've got. Okay, I will come back as soon as, if I'm told no more weddings, I'll come back earlier. I'm just sort of sitting there, sort of like Santa at the mall, but I've got wedding certificates, marriage certificates I can sign. Thank you.
Judge, before you leave, can I just
Yeah.
give you that site
Yeah.
about you can abandon an easement? It's Walker versus Georgia Power Company, 177 Georgia Appeals 493.
Say the site, not the name, but the,
177
yeah,
Georgia Appeals
Yeah.
493, a 1986 case.
okay. And that's that one can abandon, well, I know you can abandon an easement, which is what I've learned in preparing for this trial, which is a ugly, two super fancy houses. They have too much money to spend on lawyers, this little strip of land, and one kid wants to play lacrosse on it and the other side wants to raise fancy flowers or something. And you would think that it is as fundamental as I'm just trying to get to the gravestone of my great-great-grandfather. It's hard to abandon an easement.
I understand. Thank
All
you.
right. All right, thank you all. I will mute
Sorry, I saw that. Yeah, there's two to do, but just too much going on with discoveries.
I get it. No question. It's.
It's just gone through. Grab a copy.
There's still only 24 hours every day.
Do you all mind checking on Mr. McConnell just to see if he needs a couple more minutes? That's great. If, make sure we're, thanks.
Show me how you did that, how you corrected the email.
So you have to pop it out like that. Under this new tab, these the white paper buttons. So that's where your recall or recent, but it's just this edit button.
Oh, wow.
And then when you close out of it and you make a change, it'll say save. So there's the
ETA?
They're wrapping up. It should only be about another minute or so.
Okay, thank you. And be clear, I made you guys wait forever. I don't mind that they're talking a little bit. I was gonna get off the bench if it was gonna be longer and go do something back there.
I apologize.
Don't apologize. I was just explaining to your colleagues, I had you guys sit around for an hour while I was up at the Capitol. So, and then an hour while I was marrying two wonderful couples, very, very different
But
couples.
the good news is we agreed, they're fine with.
We're making progress. Great. Well, why don't we get on the record in just a second? Which means someone figures out how to press record on that little silver box. We're also making a record through the YouTube feed, but it'd be better to have it on the court reporter.
Exactly what she said to do, you hit record, dude. It's us talking about it. Over.
Welcome to the jury box. Maybe when I see you next, you'll be jurors.
I'm a secret 71.
Well, you know, some of our best jurors are those who say, I know I have an excuse, but I'm not going to use it. I'm going to come in and serve. Good. Excellent. Is the little silver box working?
We think so, Judge. It says it's recording.
Okay.
Very good.
Okay, it's ticking. That's alarming. So just for the record's purposes, we're back on the record in 24 CV 00278. Both sides indulged me in allowing me to meet my obligation to help with free weddings on this Valentine's Day as sponsored by our amazing probate judge, Judge Kenya Johnson. And I think happily, they seem very happy. One guy was crying, happy tears, performed 2 weddings. I was invited to none of the dinners tonight, despite me trying to horn in on one of them. But it sounds like during that break, Ms. Whitlock and Mr. McConnell did what I hoped they would do, which was talk a little bit about the framework of a tentative, potential, interim, non-permanent way that folks could move forward. Basically, what it sounds like is extending, I don't know any of the contours, the collaboration that existed before the tree incident, so that everyone knows what they can do and what, if they want to do, maybe they need to get input from both sides, or ultimately a green light or a red light from me, so long as I'm presiding over the matter. So having said that, Ms. Whitlock, you were the one most interrupted by me leaving, because you were in the midst of a very short presentation, not because you didn't have lots to say or hadn't done a lot of work. It's just I started with Mr. McConnell and we filled most of the time that we had before the wedding break. So why don't you start by sharing with me, and you can stay right there, Mr. McConnell, I think it'll be helpful, but with where you think we are right now.
I do need to go back and correct one thing. I said earlier that the access provision was not in our covenants, and that was incorrect. It is in the covenants.
Okay.
So I just want the record to be clear.
Good.
And then while you were otherwise occupied, Mr. McConnell and I did use our time wisely, and we have gone through his 9 points. And I have no authority. You understand, I'm a defense lawyer, so I have no authority as I stand here, but I think we have come up with a plan that I can take to my client and recommend. And what we would ask is that we have the opportunity to massage this a little bit and then present to you a consent order that says this is what we will do from this day until the litigation is concluded.
Okay. Or at least for some period of time. I mean, who knows how long the litigation will take. Hopefully, given the spirit of collaboration that has sprung forth already, we water and fertilize this sapling, and it may not be super long litigation, but it may be, and I'm here for the long haul, as long as both sides need it. I think that makes a lot of sense. I'll encourage you all to agree to disagree if that's where you get. It may be that what you share with me at a time we'll talk about in a minute is 90% everyone consents, but there may be that 10% where we actually don't agree. We need you to resolve point F, because homeowners association says no, and plaintiffs say must happen. And then I'll resolve that on an interim basis. And it could be something that changes over time too, as we flesh out the evidentiary record, because I want to put your mind at ease, Ms. Whitlock. I'm not making any final factual decisions today because of the very thorough pleadings that dropped in your lap and mine from plaintiffs. It is very thorough, and I appreciate there would need to be an evidentiary back and forth. It's the commonality of the positions that led me to think that we ought to be able to craft an interim order that has the softening of it's sort of a consent order, so neither side feels like, gosh darn it, Judge, here you go. But I do think something needs to be in place, if only to trigger the come to me so we can figure out what to do, because both sides in their desire to pursue their own interests might bump heads. And this way, there doesn't have to be a whole new lawsuit and we wait a bunch of days, but it would be as simple as emailing Ms. Niles and maybe, I can't say get on the phone because our phones don't work. Here's how I'm supposed to let security know if there's an issue. But we could certainly do a Zoom call or whatever. And I would commit to breaking from what I'm doing if it's sufficiently urgent, as in we've got a vendor who's ready to do X and there's a concern about this vendor, let's jump on it. Because I appreciate the significance of this, obviously to the plaintiffs, that's clear, but also to the defendant. It is where people live. And so not the cemetery, obviously, but they're neighbors. And so really what we're doing here is figuring out how to create good neighbors between a very important interest in maintaining whatever we end up defining that word as, maintaining the cemetery, and certainly preserving the right to quiet enjoyment that all of the members of the HOA have for the surrounding property. So I talked a whole lot. I didn't mean to seize the microphone from you, Ms. Whitlock, but you were saying that you would like some time to obviously confer with your client, and you would all build out the contours. What time frame do you have in mind? I'm not rushing anything, but I don't want you all to think, well, Judge went away, so we're not going to rush it. Because I know Mr. McConnell will say, hey, time is of the essence. What's the right balance here?
meaning Mr. McConnell, has taken some pretty extensive notes, and it's my understanding that they're going to get to us a written proposal in the next day or so.
Well, no, I mean, I literally I can scan this on my phone and email it to you. These are my handwritten. I don't have the best handwriting, but I can get this so we can get started. Meanwhile, my office will turn this into an order. We can have that to you tonight. I was able to confer with my clients, within 15 minutes. So I don't think it should take that long. So I'm hopeful tomorrow we should have an order to the court.
Okay. Well, I want to make sure, while time is of the essence, I don't want Ms. Whitlock to feel like this is something that's being rammed down anyone's throat, and that's not. But I also, if you were to say, well, we have to convene the board, and they're not meeting until March.
No, sir, I think I can get something done in a couple of days. I won't be able to get it done tonight.
Okay, I don't think tonight's. Why don't we do this? Why don't you all reach out to Ms. Niles at close of business tomorrow to let her know where you are? Because I'll jump on it right away. I want it in Word format because it's my order, not yours. And so I may want to tweak it. And there may well be, like I said, 9 points of agreement and 1 point of disagreement. And then I'll need to craft the language that resolves that disagreement in whatever way I think fits based on how I understand the case at this point. I'll reemphasize, none of this is permanent. Things may change over time. And you all may agree we'd like to modify the order because there's a new concern that's been raised by plaintiffs that the HOA has no problem accommodating, but we might as well bake it into the order so that if that order has overarching this umbrella of liability protection for the HOA, they might want it then baked into the order. So this would be yet another example of activity, if performed by not the HOA, immunizes the HOA from any liability. You're going to come up with the lawyer language. That's what you do.
Yes.
All right. Does that time frame work? As in, let Ms. Niles, it could be close of business tomorrow. Zing, here's the Word file. But if it's not, I'm not going to press Ms. Whitlock. If it's Monday and the answer is, yeah, we're still thinking about it, then I may need to set a deadline, or you may need to step back and say, I thought we could do this, but we can't. I encourage you to impress upon your client, which I realize isn't a single person, but it's a group, the value that I see from an early collaboration in this. In the end, it will be much less expensive for them. But I also respect each side's right to litigate this as they see fit.
I appreciate that, Judge.
Okay. Anything else, Mr. McConnell, on behalf of your clients?
No, Your Honor, you had some questions, but I think in light of that you wanted me to address, but in light of these developments, I think we can table.
No, I think we should save you all that time so you can start typing your handwriting, or someone can type your handwriting into legible type. You're addressing them because it had to do with liability, et cetera. I'm going to look at a couple of the cases. Some of them featured prominently in your briefing anyway. And so I had skimmed those, but I'm going to want to stay sharp on this because we do need to move the case forward. Because of the cyber incident, filing things is it's actually not complicated to e-file. You can e-file to your heart's content. It just hits this wall of the clerk's office not always being able to accept the e-filing. So you will have proof of filing, and your e-filing will be backdated to the date you actually e-file. You'll get a receipt saying, I e-filed on February 14th. If the clerk's office can't technically accept it until February 19th, it's still going to say this was filed February 14th. I don't think that fixes your default issue. But rest assured that if you're e-filing things, but you're not getting that receipt that in months past you would get, you still get credit for the date you e-filed it. That being said, because it won't technically hit the docket, you should always send courtesy copies to Ms. Niles. That's usually not the norm. We don't need a certificate of service and this and that. We wouldn't want to get that. But we can't look in the docket and see what's been going on unless you've received that receipt. Yes, it's been accepted by the clerk. Okay. So in normal times, it's safe for you to assume I e-filed it and that's going to pop up in the docket. But also right now, at least, we've got some urgency to things, so it'd be another reason to send the courtesy copies. All right, Ms. Whitlock, anything else?
Not right now, Your Honor. Thank you.
All right, I apologize again. We could have covered all this, although you wouldn't have had your break to play shuttle diplomacy before the marriage break if I had been able to be here at 1. But it was pretty clear that I wasn't supposed to leave the mezzanine 1 conference room over at the Capitol. So I appreciate everyone's patience. Happy Valentine's Day. I hope people can do something more fun than litigation for dinner tonight. And I'll look forward to something from the two sides.
All
right.
Thank you. Your
Thanks,
Honor.
Judge.
And you all will sort out, I don't know if you're splitting costs, you'll make Elizabeth Gallo, and particularly Ms. Willoughby, whole.
Yes, sir.
Okay, and you'll return, I'm sure that's not like a $5 device.
Oh, it will go back to her because I don't know what else to do with it, Judge.
Good, okay, excellent. Then you've done what you need to do, and I will see everyone next time.
Thank you,
Your
Judge.
Honor.
Take care.
I think just hold it to make it stop.
You want to turn the power off, then.